Hello, I'm the Miami Autism Dad, Victor Antunez, the inclusive Miami Realtor, and this is the Autism Podcast at Miami's community newspapers. Today, I am with Stephanie Cruz. She's an attorney here in Miami who focuses on guardianship, special needs trust, probate, and long-term financial planning for families raising children with disabilities. She's also on the board of the South Florida Autism Charter School and Gigi's Playhouse Miami, and currently serves as president of the Miami Lakes Bar Association. Stephanie, welcome to the show.
Thank you so much for having me here today.
So let's go ahead and start with your origin story. How did you first get pulled into working with special needs?
So I've been an attorney now for about 9 years. I started my career doing real estate. And then really what happened was that I got into special needs more so starting through probate. So my grandparents were getting older and the questions were, well, what happens to the house? What happens to the cars? And so I kind of segued from real estate over to estates and trusts. And then I started getting more into the special needs community through a friend of mine, Janexi Del Rio, who she's very special to me and her family. And basically she was my neighbor. And she said to me, you know what, I want to introduce you to somebody at SFAX, at South Florida Autism Charter. And that school, it's been amazing. I've been able to help so many families there, educate them. I do seminars and it's one big family. So that's really been it. And I feel that in that area of law, you have to, not everybody can practice special needs law. I think you have to have the empathy. I think you have to care. And those are qualities that I have, thankfully.
And how many years ago was that?
Well, that I've been an attorney 9 years.
No, in special needs.
In special needs, it's been about 3.
And how would you describe your connection now with that community?
I think it's beautiful. I mean, I meet the parents, so the parent will call in. Mm-hmm. We have a one-on-one consultation, 30 minutes, and we sit down and we talk. I make it very easy for them to just tell me, look, what keeps you up at night? You know, you obviously you have a child that potentially, with the trust conversation, the children are minors usually. With the guardianship conversation, they have turned 18. And then the question is, okay, well, now when I'm going to the emergency room or I'm going to the doctor, you know, they're telling me, well, your child is now an adult. You can't be present. So they usually come to me with that angst, that how can I resolve this? So then we usually at that point have the conversation of, okay, well, what type of guardianships are out there for them? To what level? Do we need a full, which is a plenary, or do we need a limited? And it's really a conversation at that point of what their child needs. And then we take it from there.
You know, and I met you at one of your presentations, and I got to tell you, it's very sobering because when you go there, you kind of feel naked because you start to realize, goodness, there's all these things I need to do and I haven't done them. And when will I find the time? And do I start now? Do I wait? So there's 2 different things. There's guardianship and there's special needs trust.
Yeah.
When should parents be getting or thinking about a special needs trust and then guardianship? Because they're 2 different things. Like what are the age ranges you're seeing for that?
So they're different and they do different things. So when we talk about trust, we talk about planning for not the child, but the parent, right? The parent's potential incapacity, the parent's passing. Right? It's how can I make sure that if those things happen to me, my kids and my family are okay. And okay means that you did not leave a mess. Mm-hmm. Okay? Because potentially, and a lot of people, you know, and it's unfortunate because everybody gets up in the morning and they go to work and it's, you know, they want to succeed and they put so much effort to acquire all these assets and real estate. And then if they pass away, it's like, well, sometimes things are not titled the way that you thought they were. Or maybe you had one of these DIY wills that you thought would work. Or maybe you just, you know, where I've had clients that tell me, look, if I'm going on a trip and if, you know, something happens to me, I wrote a letter and it's in my drawer, and which doesn't work unless it's done right. So there's a lot of misconceptions. But the trust is more so the planning. So it's basically I describe trust like a box, okay? A box, you put things in the box related to your assets and you put them in there strategically. So let's say if you have a home or you have a bank account and then you have, let's say one child, they happen to have special needs and let's say you're married, right? For that particular family, we can create a revocable trust. Okay. So both of those people, while they are alive, they can use the property, they can sell the property, they can use the money in the bank. It's only so much done in a way so that if they both are not here, then their child, let's say with special needs, would be able to use and be protected from these monies and be able to maybe have the property rented and the monies generated from the property are used for the care. We do actually do that quite a bit. And then you make them able to have use of these things, but you don't make them ineligible for certain benefits because of the fact that you gave them a property or you gave them a bank account. We have to keep them no more in their name than $2,000 because at that point they would not be able to qualify for SSI.
Mm-hmm.
So there is a strategy, there's a way of doing things. So the trust is definitely why that is used for. The guardianship is for the ability to help. It's the ability to retain that that ability to assist that you've been used to for the 18 years of that child. At the 18th birthday, that child is an adult. The same way that you became autonomous at 18, I became autonomous. Everybody, your mom just can't say, I'm going to step into Victor's medical appointment because I'm his mother. No, now you're an 18-year-old man. So the same thing, you have now HIPAA, right? Can a third party be in the room listening to these medical, issues or diagnoses? Can this person that's now 18, can they consent to surgeries? The reality is that a lot of the times I've had issues where she was a 40-something-year-old woman. She never had a guardianship and she needed an emergency hysterectomy. And the hospital was not going to do the surgery. So we had to run and do the guardianship for that to be able to get done.
And I'm sure it was more expensive waiting to the last minute, obviously.
It is. I mean, for that family, and it's a blessing for the family. Usually not the best for me. I have empathy for those situations, so I'm not really, I don't take advantage of that. Some attorneys could potentially, we're in an emergency, double the price. In that particular case, I didn't do that. But yeah, it's you're running against the clock. This person's life is potentially, going to be harmed, and you can't really. You could have been able to kind of circumvent that if you would have done it on or around the 18th birthday, which is what I recommend.
Now, speaking of these do-it-yourself wills, I've also seen do-it-yourself trust, and I'm not a big believer because I think you get what you pay for.
Yeah.
So, what are the number one mistake you see parents making before they come to you, and how do you mitigate those?
One of the worst things, and you kind of touched on it when you said when you went to the seminar that you felt kind of like naked, right? There's so much information that is either not good or half-truths. I get a lot of people that they'll go on Google or they see things on TikTok or whatever it is, and then they in their mind think that either this is easy, they can do it themselves, or that their friend that, maybe works at a law firm can do it. I always say if it was that easy, lawyers wouldn't do it anymore, right? Because you would not need them anymore, right? It's a fallacy to think that something so complex, especially a trust, to be done correctly without having the legal background, that's bad. And the problem is that it looks really good on paper, right? You can go to ChatGPT and say, create a trust for me, and I have X, Y, and Z, and ChatGPT will create something that aesthetically it looks, rock solid. You could print it out, you can take it to a notary, and then you think that you have something that's going to work. And then you go through your whole life thinking that this is going to work. And then when you go to use it, which the person is now deceased, it's too late. And now you have nothing. But you have potentially created something that people are going to fight over, right? Which is something else I see. When you do your DIYs, first of all, when you do them, they have to be submitted. Let's say a will, for example. A will that's created has to be probated, has to be used in court. So just because you have a will doesn't mean that the asset is going to flow magically from the sky. It's an instruction sheet for a judge to give you the asset. Okay. But I just drew a blank.
Well, I'll give you an analogy from my own life.
Yeah.
I got a traffic ticket once. And
Yeah.
also, you can fight it yourself.
Yeah.
So I tried it and I lost and it cost me a lot of money.
Yeah. Okay.
So the next traffic ticket I got, I called one of these ticket clinics, paid them the money.
Mhm.
Wasn't that much money. I cleared my mind of all the trauma of going to court and this and that, and they took care of it. And it was like, in the end, you paid less. You think you're going to save money doing DIY, and you just
No,
don't.
and a lot of people will fight over documents that are wrong, right?
Right.
And something else, like I've had wills come across my desk and they say, well, I give my house to my child, and they're married. So you can't do that. There's certain things, just because the paper, as we say in Spanish, el papel lo aguanta todo, right? Just because the paper says I give my house to my child, that's illegal in Florida.
How is it illegal?
Because you can't disinherit your spouse from the homestead.
Oh, okay, got it.
Without
Okay.
the spouse
Right, okay.
agreeing, and there's very specific statute language that has to be
Yes,
on
yes,
there.
okay.
So people do that, all the time. And
Just naive. Super naive.
they're not naive. They know that they shouldn't be drafting their own documents. The same way they know that they shouldn't do their own like dental work, right? But they do it anyway because they think that it's just a paper and it's simple and that lawyers charge too much, right?
We're Miami, they're being tacaño, cheap.
Yeah. But you know what? Unfortunately, a lot of the time when they are doing that, there's going to be more money spent on the back end.
Yes, that happened to me with my traffic ticket.
Yeah.
I spent more money in the back end. Now, I want to use my daughter as an example because she's 8 years old. So 8 to 18, we got 10 more years. So guardianship can wait, obviously.
It can wait.
Special needs trust, wait or do it now?
I would say do it now because you would prepare your estate now. It grows with you, so you can modify and you can make changes. You acquire more assets. You have more children, or there's any major family change. It can be modified in that document. But if something were to happen to you, God forbid, your assets are going to go where you want them to go, and your daughter will be able to be cared for.
And if I don't do that, what happens?
If you don't do that, then the first step will be guardianship. Well, the first step would be probate.
Okay, that's what I was asking.
Probate.
Right.
The money that you have, all of the homes, any assets that you have, it's going to sit frozen there until a judge gives it to whoever it belongs to. So money in the bank.
Whoever they deem it belongs to.
Whoever they deem by statute. If you don't have a will,
Mm-hmm.
or if you have a trust, they're going to, or a will or a trust, they're going to first check. A will has to go through probate. A trust does not. But given the timing that we have, it's a lot to discuss. But a trust is preferable because it avoids probate. That's important for your viewers to understand. A trust is preferable because it avoids probate and it gets the asset to your daughter without the need of court intervention. So it is more economical, it is more structured, and it's just a safer.
And it's what I wanted, not what the court deems.
Exactly.
Right.
Exactly. So let's say you didn't have a trust, you didn't do any sort of planning. The court will first see in probate if you have a will or if you have anything. Let's say you have nothing, then there's laws on the books called the intestacy laws, and they're going to govern where your things go. So they're going to see. So everybody has basically a one-size-fits-all will. It's called the intestacy, and you can read up on it, and it'll tell you if you're married, and that spouse is the mother or the father of your children, then that spouse gets everything. If you are married, but you had a child from another relationship, then now your current spouse gets 50% and your kids get the remaining. And some people, that takes them aback quite a bit. So if that doesn't work for you, have something. Have at least a will. So then the will has to be, let's say you have a will. The will be administered in probate court. Usually the statutory fee for the attorney is 3% of whatever you left. So it's very expensive. And then because one of your heirs is a minor, she's going to need a guardianship. So guardianship is split between the person and the property. So because she's not an adult, you would need at that point just the guardian of the property. So let's say her mother, although she is her mother and she's her natural guardian, she's not the guardian of the property. So your wife would technically have to petition, which that is jarring for some parents. It's like, why would I have to prove that I am my child's mother? Well, because the court has to make sure that you have all of the best of intentions.
We're protecting the children,
That's really what it is.
basically.
Yeah.
Give me a scary story. People that didn't leave guardianship or trust, and
Well, I mean, the scary story, one of the bigger ones was that one where the woman had cancer, unfortunately, and we were running. And at that point in time, I was having an argument with the, not the court. It was basically the court appointed attorney for her, because when we petition in guardianship, we are petitioning for the parents. The court gives the AIP, the alleged incapacitated person, an attorney, right? And that person is looking out for them. This particular attorney did not agree with me that this was an emergency. So we had like a whole hearing on whether this was an emergency. So that for me was very frustrating. And as far as scary story, I mean, these things happen where people they pass away. And the question is,
young.
they pass away young. They pass away. The parent has a special needs child. They pass away young. And the question is, you have a child that is nonverbal. You have a child that is used to seeing their mother, for example, every single day. And then now they not only have to deal with that, they have to deal with where do they live? Who's paying those bills? Because when you pass, those bills are still due. And the sad part is that the money to pay the bills are now frozen. And that is something that is incredibly jarring for a lot of people. And even for a spouse thinks that, let's say they are not on a bank account. Let's say the spouse that passed was the one that had all of the money in a particular bank account. That bank account, they are not going to be able to legally access it unless they were a co-owner on that account. The same for the real estate. If you have one person on title and you don't have that second spouse, which I see quite a bit, because a lot of the times they're told, well, if one spouse buys the house and then you guys can buy it under the other spouse's name, and they do it for those reasons, and then they're actually shooting themselves in the foot in the long run for certain situations. So it's just, there's a lot of scary stories, but I can tell you that it is incredibly scary when you have a special needs person that you don't have a guardianship for, you don't have money for them, and you have to go through a bunch of legal court processes just to get them back to a routine. So it's important.
Let's talk about guardianship. So you have 3 different types I'm seeing here: guardianship advocacy, and supportive decision making. Briefly unpack those for me.
Yeah. Okay. Well, there's a lot of, and you'll see a lot online about guardianship alternatives, right? Guardianship alternative. So you have a special needs adult. Let's say they've turned 18 years old. Let's say they're nonverbal and they need a lot of support. Okay. I'll have a parent call me and she'll say, well, I want an advocacy. Okay. You want an advocacy maybe because you heard about this online or whatever it is. But understand that you don't choose really what your child really needs. Or I want a power of attorney. That's another one. Or advanced decision making. If your child needs more support, then we should explore the guardianship versus the alternatives to guardianship. Because that's what's going to give you, mom or dad, we're going to take the rights away and then we're going to give them to you. Okay. Now, some parents are like, well, I don't want to feel that I'm taking all of my child's rights away. Okay. Well, the decision is going to be, the court is always going to look through the less restrictive means. That's the goal. Okay. They don't want to take more than they have to. How the guardianship process is that 3 doctors will evaluate this, what they call the AIP, the alleged incapacitated person. And they're going to see, okay, what does this child, now adult, need? Okay. Do they need all of their rights taken away? Do they need some of their rights taken away? And then the delegable ones are going to be given to mom and dad. Okay. So I think that guardianship is something that should be considered, especially sometimes when we have an adult that could potentially have violent outbursts. Okay. If you have a child that could do something that could potentially get him in trouble with the law, it's better for them to be declared incapacitated when they are facing any sort of criminal charges.
And you have seen this. I think you spoke about it.
This is not a particular situation that I was involved in, but I had a colleague attorney friend of mine that told me that, and it's quite sensitive. This special needs adult was looking at, pornography online, and he ended up watching child pornography.
Oh, goodness.
And there was a raid, and he got into very, very serious trouble. And the whole argument was, well, he did not have the capacity, right? He did not have the malice minor, what we call the mens rea, to do this crime. But at that point, they were trying to seek guardianship, and from what I was told by my attorney colleague, it didn't fly.
So if they had guardianship before,
it would have made a huge difference.
Huge difference, like
between
difference. Jail and no jail.
Yeah, because at that point in time, is this more so, are you doing this guardianship as a defense to the crime that you committed, right. Or have you already been declared incapacitated, years ago? So in that particular, that's a scary story in of itself, and that should have, if the parents would have maybe just looked into it a little bit more and said, okay, well, let's be honest about what our son could potentially get his hands in, it could have been a different result.
Okay. Now, as a dad planning for my daughter, she's 8 now. So 8 is too young for guardianship to even be thinking about it. When do I start looking at it? 15, 16, 17?
I usually recommend 17. To try to look around for an attorney. Okay. We can't file until the 18th birthday.
Oh, really?
Yeah, we can't, because...
How long is the process?
About 2 months, 2-ish months.
What if they get into trouble in those 2 months?
Well, you have at that point in time declared incapacity, right? Generally, we try to file like on their 18th birthday. Okay. And then the actual guardian. So it's a 2-part process. The incapacity is one part.
That's beforehand.
That's at the 18th. We file for that.
Okay.
Okay. And then the actual appointment of mom and dad, for example, will be after. So within like a 2-3 month span, that whole process should be done. Some attorneys are a little bit more proactive than others. I've had parents that will tell me, oh my God, this has been something that, is taking forever. Thankfully, in my office, we have a system that we are very good and very diligent at making sure that we get all of our ducks in a row. As the parent, you guys have to do your fingerprints, you have to do applications, you have to sign all my DocuSigns. Sometimes it's a little overwhelming, or when I have parents that are separated, let's say mom wants to do it, dad doesn't want to be involved, or maybe dad doesn't want to be involved really, but he wants to be co-guardian. All right, dad, you're going to have to do your fingerprints too. You're going to have to be involved in this as well. Something that is important to mention to your viewers is what happens when one parent says, I don't want to do the guardianship, and the other one does, right? A lot of the time it's like, well, I'm just going to say dad, but it could go either way. Dad's like, my son doesn't need that. Okay. And mom's like, yes, he does. So she can petition on her own. She doesn't need dad. And what we do is, we do need to let dad know. We need to give dad formal notice, which is called, basically we send him a copy of the petition and we tell him you have 20 days to provide some sort of an argument. If you don't provide an argument within those 20 days, let's say you just toss the paper, I show that to the court and we can move forward. Okay, so that's something that is important because I get that question asked regularly. You asked me about, you said guardianship. What was the others?
I forgot now.
Okay, you said just supported decision making.
Oh, okay. There was different types of guardianship.
And advocacy.
Yes.
So advocacy and supported decision making, you do not get the incapacity. They are not declared incapacitated.
And why would a parent choose that?
Again, why would they want an advocacy versus a guardianship? Honestly, I think it's because they don't want to feel that they're taking away something from
the autonomy of their child.
Right. A lot of the times the parents struggle with that because they feel like, oh my God, I'm incapacitating my child. And I can understand that can be, I get it. But it's not so much for the parent to decide. The parent can petition for advocacy, and the judge, if that child is not able to, the statute for advocacy says that they need some support. If you as a parent know that child needs more than some, right, then we shouldn't even waste time going the advocacy route. Some attorneys, it has come across my desk that the child is nonverbal, needs a lot of help, and they have an advocacy in place. And I tell the parent, well, why did this happen, or why did you choose this? A lot of the times they say, well, this was during COVID, so maybe it kind of flew under the radar a little bit. and this appointment was done or this advocacy was entered, but it really shouldn't.
Okay, this kind of like frightened me because you talked about there's 3 different doctors that will look at the child and make a determination. How can that fly under the radar if you've got 3 different professionals?
Well, the petition shouldn't even have been filed in. The advocacy should not have even gone through. From the moment that the professionals are saying,
I mean,
this
nonverbal.
person, right, then it should have been, basically dismissed.
And
right?
why wasn't it? Do you know?
No, I don't.
So, speaking of this, where do you see the system failing these individuals and their families the most?
One of the things I can tell you right now that I'm having issues with, and I've reached out to try to see if I can help fix it. Just give you an example, the right to travel. The right to travel, one of the rights that are removed is the right to travel. So technically they can't go and buy a plane ticket and go wherever they want.
Who would prevent them?
It would be technically legal for them to buy the ticket. The safeguards in place,
Mm-hmm.
I don't even think there are any, to be honest.
Yeah,
with
like
you.
if I go to the airport and just buy a ticket, who's going to stop me?
I mean,
Or they,
but
the
but
child.
that is what's happening, because I had a case where the right to travel was removed, and technically for mom and dad to take child, let's say, to New York for New Year's, you would have to get a permission and an order from the court to even allow the child to travel outside of the state. A lot of and so my that particular mom, she was really upset. She's like, we like to travel. We don't need to ask permission. So I go back to the doctors and I say, well, you remove the right to travel. And the doctor's like, no, but mom can take them anywhere she wants. But then I'm hearing from the courts that that's not true. So there is a confusion as to the right to travel. People are traveling, which they should be with their child, but technically they're supposed to ask for permission, but then some people say you don't. So that's already confusing enough as it is. I think that the process and judges and the legal community are already talking about that there needs to be some sort of a change. Commissioner Regalado, for example, she's a champion in this community, and I've spoken to her a couple of times, and she's one of the ones that tell me, there has to be some sort of a change with this process.
What would that change look like to you?
I think if they can carve out in guardianship, maybe not make it so. It seems to me like it could be very restrictive still. Like if they can kind of do some sort of some hybrid maybe with guardianship and the advocacy. But I right now I don't even know what that would look like.
It's tough.
It's tough, but I think the system, you have to understand that this guardianship system with young people historically has been more so for elderly people. Okay. Because of the change that we see more people having special needs younger, it's the same system. I filed the same petition for incapacity for an 80 plus with Alzheimer's than I do with an 18-year-old with special needs. It's the same process. You're dealing with a different, it's an older person versus a younger person. They have different needs. It's the same process. So I think that definitely should be looked into and try to tailor it more so for who you're dealing with.
Now you talk about the system. Each state has its own system, yes?
Mm-hmm.
And where do you see, how does Florida make it easier or harder for these individuals, and people at the younger age?
Something that is a huge issue is the annual plans. The parents are going crazy over these annual plans. And recently there was a change with the credit report. All the parents had to give me their credit report and submit it to the court. So the parents are very frustrated with the fact that every year after there's a guardianship, there's a upkeep, or else the parent gets in trouble. So that's what is a little frustrating to them.
Well, I just got the 2-minute warning.
Yeah.
Half an hour, it just flies by.
It did fly by.
I know.
We talked about so many things, though.
I only got halfway through my Q&A, so this is kind of like killing me. So what I want to do now is 5 rapid fire questions.
Okay.
Things I don't think that we covered, but if we did, we'll cover them again. So true or false, my child gets SSI, so I can't leave them anything.
That's not true. That's false.
True or false? Once my child turns 18, I lose all legal rights unless I get guardianship.
True.
True or false? Guardianship is forever and there are no alternatives or changes.
Guardianship is forever as long as it is needed. If the child gets better, then you can get your capacity back.
Speaking of autistic kids, you see them getting better with age?
Some do.
Yeah.
Some do. And that's wonderful. And I hope that trend to continue,
That is
especially with more people talking about it, more money being poured into it. So hopefully that'll continue.
And I've heard that before from people that are like psychologists. So that's really good that you also confirm that.
Yeah.
Okay, last question. True or false? If I have a will, I don't need a special needs trust.
That is false. It depends though what you need. What are your needs? So as a special needs parent, you definitely need a trust. That's my opinion.
One last question, actually. Okay. And this is a big one. True or false? Naming a sibling as guardian is always the best plan.
Not always, no.
And sometimes that can really backfire.
It depends. A guardian, so you can, let's say we do mom and dad, and then later on we petition to have a standby. Siblings, and especially I've seen some of these siblings are diehard for their brother or sister, and it's beautiful to watch. But there could be anybody else. It could be a niece. It could be a friend. There's also professional guardians.
Right.
So just put the right person in that place, because once you have them there, they have a lot of power. There are safeguards, but it is a position of power.
Great. Well, Stephanie, this has been one of my favorite conversations, actually.
Really?
Yes. And we're going to talk.
I'm so happy to hear that.
We're going to talk more off camera because this is something that more parents got to talk about. And I've definitely got to talk about this with you off camera. So let's go ahead and turn to the camera.
Okay.
This has been the Autism Podcast at Miami's Community News with Stephanie Cruz. Thank you again, Stephanie. This has been super, super awesome.
Oh, thank you for having me.
Thank you for joining us, and we'll see you next time.
Bye. Bye, guys.